Young people's rights with police and authorities. Hi, I'm Jordana. I'm a lawyer with Youth Law, a community legal centre for young people under the age of 25 in Victoria. When dealing with police and other authorities, young people can find themselves in situations where they're not sure what their rights are. They can be uncertain about what police and other authorities have the power to do. If a young person is arrested and interviewed for a criminal offence, they might not know how to assert their rights and how to get help if they have to go to court. If a young person comes to you for help understanding their rights, what should you tell them? And if they are arrested, questioned or taken to court, what can you do to assist them? For part 1 of this session, I'll take you through the different powers that police and other authorities have when dealing with young people. I'll talk about the rights that young people have when dealing with those different authorities and where they can go to make a complaint if authorities don't respect their rights. This session will cover not only police, but also other authorities who are given special powers by law, protective service officers and authorised officers who have special powers on public transport. I'll also talk about security guards, bouncers or loss prevention officers, authority figures who don't have special powers by law, but who often come into contact with young people. For part 2 of this session, I will explain what happens when a young person is arrested and then interviewed by police. We'll discuss what rights a young person has in that situation and what you can do to support them. If they end up in court, we'll talk about how you can assist them by linking them up with legal advice and representation, writing a support letter for them, or accompanying them to court. Throughout this session, we'll discuss some case studies and frequently asked questions so you can see how the law applies in practice. The people and events described in the case studies are purely fictional. And please note, the information provided in this session is intended as a general guide only and is not legal advice. You should not act on the basis of this information without first getting legal advice about your own particular situation. The information in this session is based on the laws of Victoria as at August 2012. To begin, let's look at police powers. In the following scenario, think about what powers the police have and what rights the young person has. Ahmed is 19 years old. He was hanging around with some of his friends on the steps of the train station, and they were just talking and joking around while they were waiting for another friend to get there. 3 police officers approached Ahmed and his friends and said they'd received complaints from other people in the area who felt intimidated by him and his group. They told Ahmed and his friends they had to move on, and they weren't allowed to come back to the station for another 12 hours. Ahmed told the officers they had no right to move him on, and then one of the officers pulled Ahmed aside and asked Ahmed for his name and address. Ahmed refused, and the police officer told him, "If you don't give me your name and address, I'll have to move you out of here in a divvy van." Ahmed responded with a few swear words that I'd rather not repeat. So, did Ahmed break the law? Well, it's an offence to use offensive language in a public place in Victoria. If a police officer hears someone swearing, they have the power to issue an on-the-spot fine or to issue a criminal charge. It's not clear whether a court would agree that a swear word Ahmed used was offensive. Whether a swear word is offensive enough for this charge to be proven in court depends on contemporary standards and context. If Ahmed gets a fine, that alone is not a finding of guilt, so it won't come up on his criminal record. But is it fair that he got the fine? And will he even be able to pay it off? Well, that's something he can call Youth Law about to get more advice. Did Ahmed have to give police his name and address? Generally, police need a reason to ask for your name and address. A specific reason, like they believe you've broken the law or are about to break the law. Police can also ask if they believe you have information that can help them investigate a crime. Another situation where you have to give police your name and address is if you're driving a vehicle. If police pull you over for any reason, you must give police your name and address. If police ask you, and they have a valid reason to ask for your name and address, it's an offence to refuse to give your name and address or to give a false name and address. Even if you're not sure that police have a valid reason, it's best to give your name and address, and we'll talk about how you can make a complaint later. Did the police have the power to move on Ahmed and his friends? In Victoria, there are laws that give police powers to move people on from a public place. Police can move you on if they believe you are disrupting or are likely to disrupt the peace, or if police believe that you are behaving in a way that might be dangerous to public safety or likely to cause injury or damage to property. This law doesn't apply to protests and demonstrations, so people shouldn't get a move on order from police in those sorts of situations. If asked to move on, you have to stay away from the given area for the period of time that police tell you. The order can be given verbally, and you can be asked to stay away for anything up to 24 hours. It is an offence to refuse a police order to move on or stay away. Unfortunately for Ahmed, he won't be able to catch the train home from that station without facing a possible charge or fine for disobeying the order. But were Ahmed and his friends really disrupting the peace? Or were they doing anything dangerous? So what were Ahmed's rights in that situation? Ahmed had the right to ask the police why they wanted his name and address. He also has a right to ask the police officer for their name, rank, and place of duty, and to see his ID if he was not in uniform. The officer can be fined if he refuses to give Ahmed that information. Ahmed also has the right to use the public space just like anyone else, and to be free from discrimination because of, for example, his age, race, or religion. He's got a right to privacy and a right to be free from arbitrary arrest. He's also got the right to silence when police question him. It can be difficult, but it's important young people in these kinds of situations stay calm, take note or remember as much as they can about the situation, and make a complaint afterwards if they feel the police have treated them unfairly or did not respect their rights. What should Ahmed do if he wants to make a complaint about the police? Anyone making a complaint should try to gather as much information as they can about the incident. As soon as they can, they should write down their account of what happened, including the name, rank, badge ID, and station of any officers involved, the name and contact details of any witnesses, the date, the time, and the place that the incident happened. If Ahmed was hurt by police during his arrest or at the station, he should see a doctor as soon as possible and get photos of any injuries, preferably photos taken by that same doctor. The person should note down who was the last person that saw them before they got injured and the first person they saw after. But most importantly, they should contact a lawyer. There are a few different options for making police complaints. You could go to the station and make a complaint to the sergeant on duty or officer in charge. You could go to Victoria Police's own Ethical Standards Department, or you could go to the Office of Police Integrity. It can be difficult to know the best way to go about making a complaint. So again, Ahmed should contact a legal service like Youth Law for advice. Besides police, other officers that are given special powers by law are protective services officers. The Victorian Government has recruited a number of PSOs, or protective services officers, to patrol train stations. PSOs pretty much have the same powers as police if they are on duty in or around designated areas. Designated areas include train stations or the areas next to train stations, like car parks, roadways or thoroughfares in and out of the train station, or bus bays and taxi ranks near the train station. PSOs have the same powers as police to search you, fine you, arrest you, or order you to move on if you are in a designated area. PSOs must hand you over to police if you are going to face criminal charges in court. What if a young person was out and about on public transport and came across a protective services officer in a situation like this? Melindy is 17 years old. She took part in a local youth art program where she was allowed to take a spray paint can home with her. On her way home, she was waiting at the train station and leaning against a wall. A protective services officer, or PSO, came up to her and pointed to some tags scribbled on the wall in black marker pen. He accused her of doing the tags because he could see blue paint on her hands and around her mouth. Melindy tried to explain that the paint on her hands was from the art program and it was a different colour to the tags anyway, but the PSO didn't listen. He asked for her name and address and she gave that information to him, but then he said he was going to search her bag. She refused to let him search her bag, so the PSO grabbed Melindy, held her arms down and took her bag from her and looked inside. In there, he found the blue spray can and a plastic bottle full of blue paint. The PSO confiscated the spray can and fined Melindy for being in possession of the spray can. Did the PSO have the right to search Melindy's bag? Graffiti Laws in Victoria give police and PSOs the power to search anyone over the age of 14 if they have a reasonable suspicion that they're carrying a spray can. Simply being in an area where there is a lot of graffiti, or a location that had been recently marked with graffiti, like the wall that Melindy was standing in front of, can be enough to justify the PSO having a reasonable suspicion. When carrying out these searches, police and PSOs can inspect your bag, ask you to take off your hat, coat, outer clothing or shoes, or do a pat-down search. It is an offence to resist a valid search by a PSO or a police officer, and they can use reasonable force to carry out a valid search if you refuse. Even if you're not sure whether the search is valid, it's best to allow the search to take place and make a complaint later. Can the PSO fine Melindy just for carrying a spray can? Carrying a spray can isn't an offence by itself, but it is an offence if you're carrying that spray can on or near public transport or while you're trespassing on private property. This is regardless of whether or not you even marked graffiti or were about to mark graffiti. Being on or near public transport includes being on the platform, like Melindy was, as well as adjacent public spaces, like taxi ranks or the station car park. There is a defence of reasonable excuse for carrying a spray can on public transport, but only if you're using it in your trade, employment or profession, and it's up to you to prove this. So that's why Melindy got fined by the PSO, and it doesn't sound like she has a defence if she wasn't using the spray can for her job. But things might be different if she was chroming. Melindy had paint around her mouth, and the PSO found that bottle of paint in her bag. So she might have been chroming. Should the PSO have done something about that? Chroming. It's not an offence in Victoria to chrome, that is, inhale volatile substances like spray paint, so the PSO can't fine or charge Melindy for that. Police and PSOs actually have special obligations if they apprehend someone who is under 18 years old and they reasonably suspect that that person is abusing volatile substances. They must stop the search and carry out those obligations, which include apprehending the young person and then linking them in to suitable care with a parent, a caregiver, a hospital or a drug treatment agency as soon as possible. If the PSO suspected Melindy of chroming, and in this situation he should have, the PSO did not fulfil his obligations. By law, the PSO can't fine Melindy if she was using the spray can for chroming, so in this case she may have a valid defence to the fine. So what were Melindy's rights in that situation? Everyone has the right to be free from cruel, inhuman and degrading treatment. So if the PSO has used more force than is reasonable to carry out his search, then he has breached that right. Melindy has the right to ask the PSO his name, rank and place of duty. The PSO has to write this information down for Melindy if she asks him. Police or PSOs who conduct a search like this must make a written record of the search, which includes their name, rank and station, the date, time and place of the search, the name of the person searched, any items that were seized, and the grounds for the search. By law, Melindy also has a right to request a copy of this record. She can get that for free if she makes the request within a year of being searched. This information could also help Melindy in making a complaint. How should Melindy go about making a complaint? The options for making a complaint against a PSO are much the same as for making a complaint against police. Melindy could make a complaint to the PSO superiors at the Transit Safety Division of Victoria Police, who oversee PSOs in train stations. Or Melindy could make a complaint to the Victoria Police Ethical Standards Division, or the Office of Police Integrity, for serious misconduct like assault. Again, Melindy should seek advice before making a complaint from a legal service like Youth Law.